law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey everybody, welcome to what's normally the Law of Self-Defense news and Q&A show. We're doing things a little bit differently this week. Instead of doing use of force news items and then a little bit of Q&A, we'll be covering throughout the course of the next hour or so the evidentiary hearing, the pretrial hearing that took place with respect to the Kyle Rittenhouse case. It took place last Friday, I believe, and we're just getting around to doing our in-depth analysis now. We're going to share all of that with you over the course of the next hour as part of the Law of Self-Defense News and Q&A show for September 23rd, 2021. Please come on in, make yourselves comfortable if you're watching this live on Facebook or live on our members portal. I'm being told I don't have audio. Let's see, can someone give me an audio check? Maybe on Facebook? Because it appears to be working properly on my end. Check. Okay, looks like audio is good for most people. Steve B. over on the membership page. Sorry, Steve, you might want to reboot your computer or I'm not sure, try something on your end. But everybody else is telling me that they are receiving audio properly, so we're going to go with that assumption, despite our share of failures on that front in the past. So, for those of you who may not know, here at Law of Self-Defense, we cover use of force law from an attorney's perspective. We don't have a generalized criminal defense practice. We don't do DWIs. We don't do shoplifting. We do nothing but use of force cases, which is self-defense, defense of others, and defense of property. I myself, of course, am attorney Andrew Branca for Law of Self-Defense. Thank you. That's always greatly appreciated. And today we will be talking about the Kyle Rittenhouse case, with particular focus on the pretrial evidentiary hearing that took place for this case just this past Friday. And folks, this was a very bad day for the prosecution. A lot of the evidence they hope to get in, one, is not being admitted by the judge, who, by the way, appears to me to be doing an absolutely fantastic job. Way back in, it was, I believe, February of this year. Let me see if I can pull that up. If I have a record of that. I looked it up, but I forgot. I will put it was February 16th, 2021. There was a much earlier pretrial hearing in this case, and the Judge Schroeder, the Kenosha County Judge, Bruce Schroeder, when he had that hearing back in February, I did an entire blog post on it, headlined, "It looks like Kyle Rittenhouse got a great trial judge for his case." And folks, that was only more affirmed today. Judge Schroeder looks like he's going to be a fantastic judge for this case, which I am, of course, extremely pleased to be able to report. Very no-nonsense, very realistic understanding and application of, in this context, the laws of evidence to this most recent hearing this past Friday, and not being gulled or bending the knee to the prosecution as we too often see in these highly politicized cases. So I will put a link in today's content, the text version of today's content for our members, back to that February post, so you can see my take on Judge Schroeder there as well. But certainly I think he did a fine job today. And we'll step through some of his decisions on evidence in today's hearing. And more importantly than just the decisions themselves, which of course you could get by watching the roughly 3 hours of hearing video yourself, I'll try to explain how he arrived at those conclusions and some broader implications as well. Before we jump into the meat of today's content, however, I am, of course, obliged to Mention our sponsor, which once again, I'm pleased to say, is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe effectively promises its members to cover their legal expenses if they're involved in a use of force event. And those legal expenses start big and get bigger fast, folks. In a case in which you might have defended yourself with deadly force and killed your attacker and are now found yourself facing a charge of murder or manslaughter, it is very common to run up as much as or more than $200,000 worth of legal expenses pre-trial, folks, before you ever get to trial. In the well-known, poorly understood, but well-known George Zimmerman trial, the legal expenses amounted to the millions of dollars. So these expenses can get big very, very fast. It can be very helpful to have a financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you need it fought, which is as if the rest of your life depended on it. Because, folks, it really does. I've looked at all the various quote-unquote self-defense insurance offerings out there. As you might imagine, I found that by far the best fit for me is CCW Safe. I myself am a member of CCW Safe. My wife, Emily, is a member of CCW Safe. Whether they're the best fit for you, however, is a decision only you can make. But I do encourage you to take a look at what they have to offer by pointing your browser after today's show to lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can save 10% off your membership using the discount code LOSD10, which is LOSD for Law of Self-Defense, and the number 10. Seriously, folks, the longer I'm a member there and the more I interact with and work with the CCW Safe team, the happier I am and the more impressed I am. They do a absolutely fantastic job, in my opinion, head and shoulders above anybody else in this space. So I urge you to take a look, lawofselfdefense.com/CCWSafe, and save 10% with discount code LOSD10 for Law of Self-Defense 10. Okay, so let's jump into this. So last Friday we had, and by the way, for our Law of Self-Defense members, you'll get not just the video of today's show where I'm discussing this, as I am now, but also a somewhat condensed video of the hearing itself, because there are breaks and such. I took those out, and a transcript of the entire hearing. So if you'd like to have access to that, that's available at the Law of Self-Defense website in the text version of today's content, but only to Law of Self-Defense members. That will be available only to our membership, which is, frankly, almost free to try, folks. So if you're at all interested, you can get a 2-week trial to being a Law of Self-Defense member for only 99 cents. If you decide you don't like it within that 2-week period, feel free to cancel. We'll refund 200% of your 99 cents. And if you stay a member, it's only about $0.25 a day. And we do have a lot of trials coming up before the end of the year you may wish to access our insight and analysis on, including, of course, the Ahmaud Arbery trials down in Georgia, which involved Ahmaud Arbery, quote-unquote, jogging down a street before being stopped by the McMichaels in their pickup truck and their neighbor, Brian Roddy, behind them filming on a cell phone, with the ultimate outcome being, of course, the death of Ahmaud Arbery. All three of those men are now being charged with murder and other crimes. We'll be covering that case in minute-by-minute detail. And then, of course, this case, the Kyle Rittenhouse case, which we'll be covering live as it's televised each and every day and in real time over the course of the day, starting November 1st. For that case. We'll be covering the jury selection, the voir dire process as well, naturally. Oh, sorry, I think I forgot to provide the URL there. So if you'd like to try out that 2-week free trial, not free, 99-cent trial membership, you can access that at lawofselfdefense.com/trial. That's lawofselfdefense.com/trial. It's a negative risk proposition, folks. We'll give you 200% of your money back, and it's less than $10 a month to be a member if you decide to stay, as virtually everybody does. So, with that out of the way, let's jump back into the hearing itself. So we have this evidentiary hearing, very common, of course, in trials. One of the core functions of a trial court is to control the legal arguments and also the evidence that's allowed to be presented to the jury. The prosecution and the defense are not simply allowed to present any evidence they want to a jury. The evidence has to meet the approval of the trial judge. And two of the most important criteria for evidence to be admitted is its value in terms of relevance, how probative it is. In other words, how much it would help the jury come to a decision on an essential fact in the case, an element of the crime charged, for example, or in this case, an element of the legal defense being raised, which is, of course, self-defense in the case of Kyle Rittenhouse. So how useful is it to the jury to answer an actual question in the case, an issue in the case, and balancing that relevance, that probative value, against how prejudicial the evidence is? So it's not even enough that the evidence may be useful to the jury. It has to be more useful than it would be prejudicial. And by prejudicial, we mean that it would unfairly bias the jury against the defendant in ways that the law simply does not permit. So the offered evidence has to be relevant, and it has to avoid being overly prejudicial. It might be a little prejudicial, and that's fine, so long as it's highly relevant. But if it's not relevant, then it wouldn't be admitted. If it's not relevant at all, it's not admissible. Clearly, it's of no practical use to the jury. If it's modestly relevant but highly prejudicial, it wouldn't be admissible because of that imbalance. If it's slightly prejudicial but still highly relevant, well, then it still might be admissible evidence. So often before the trial starts, you don't want these issues about whether the evidence is going to be admissible or not to be argued while the trial is taking place. First of all, the jury's not allowed to hear these arguments. Obviously, it could be decided that a particular piece of evidence is inadmissible. You can't have that argument in front of the jury, or they've already been made aware of the evidence. So you have to have this argument outside the hearing of the jury. You prefer to do that before the jury's even been selected, so that when the trial actually starts and the jury's in the booth, you don't have to constantly have them exit the courtroom, so you can have these discussions outside of their hearing. And that's what we're doing in this case. What we did last Friday for roughly 3 hours is argue in front of the judge, but before a jury in this case even exists, about what particular aspects of evidence will be admissible. Now, generally speaking, most of the evidence in the case is not really being contested, so it's mostly admissible, but there's often pieces of evidence kind of on the margins that one or the other party would like to present to the jury, but the other party has an objection. And that's partly why we have an adversarial legal process, folks. So you have one side, I'd like to get evidence, piece of evidence number one in front of the jury. The other side objects. They argue it out in front of the judge, and the judge makes the final decision. And by the way, that decision is almost entirely really final. The appeals courts give very broad discretion to trial judges to make these calls on evidence. And there's a number of reasons for this, but the most practical is that the appellate courts don't want to do the job of the trial judge. If they wanted that job, they would have stayed trial court judges and not become appellate court judges. So the trial courts have one job and the appellate courts have a different job, and initial matters of evaluating evidence fall within the scope of the trial court, and the appellate courts are loath to assume that burden themselves, which means that when a trial court judge makes a decision on whether a piece of evidence would be admissible or not, unless that decision is really egregious, what the appellate courts would call an abuse of discretion, that decision's effectively final. So your lawyers better be making their most compelling arguments for or against a piece of evidence right there in front of the trial judge, because the notion that you might effectively challenge that trial judge's decision on appeal, either after a verdict, or in some states they allow you to go directly, immediately to the appellate courts on a particular question of evidence. The prospect, the likelihood that you would get that trial judge's decision reversed is very, very low. It does happen, but it's very, very unlikely because of how high the standard is for that to happen. So whatever decision you get out of the trial judge is probably the decision you're stuck with for the entirety of your trial. Your lawyers better be making their best arguments right there. In this particular case, a lot of the evidence around the Kyle Rittenhouse case, and of course, essentially what he did was he shot and killed two men and rather grievously injured a third man. And that's led to charges, 2 counts of murder, a charge, some form of aggravated battery for the injured man, and then a variety of other charges the prosecution's ginned up in this case. And to all these charges, effectively, except there is a gun charge still in play here. I'm not sure it'll end up in the trial. The judge here, Schroeder, hasn't yet made a decision on that. But all the use of force charges, the murder charges, the charge for the injury to the third, quote-unquote, victim in this case, the legal defense being raised to all of them is self-defense. And in fact, Rittenhouse was indisputably being pursued and arguably attacked by each of the 3 men he shot. So he's got on its face a very viable self-defense, legal defense for all 3 of those shootings, each in succession. And we actually see this as we go through this evidentiary hearing. The specific pieces of evidence that are being proposed and either approved or rejected by the judge are kind of on the margins of the case. But you can tell where a party thinks it's strong or weak based on the nature of the evidence it's fighting for. If they're fighting hard for weak bits of evidence, that suggests that they don't have a strong core of direct evidence in their favor. And I think we see that here in the prosecution's arguments for the evidence they're trying to get admitted today. So most of the evidence here is not in dispute. Rittenhouse definitely shot these people. He's not disputing that. That's inherent in the nature of a self-defense case. He's not saying it wasn't me, I have an alibi, I was someplace else. He's saying it was me. I shot them intentionally, but I did so with the legal justification of self-defense. So the use of force itself is inherently conceded by the defense in this case. The only really questions in dispute are those elements of the claim of self-defense. And hopefully by now all of you know the 5 core elements in the claim of self-defense are innocence, imminence, proportionality, avoidance, and reasonableness. We won't dive into those today for purposes of remaining within the hour of the show. Instead, we'll focus on the types of evidence that the prosecution and the defense argued to be brought in today. So the first piece of evidence the prosecution tried to bring in, get admitted into evidence, approved by trial judge Schroeder, is what's known as other acts evidence. So it involves an act that's separate from the core events that underlie the criminal charge. But the prosecution is arguing that these other acts will inform the jury in some way, provide some context, be evidence of some kind of motive or intent or a modus operandi, a very definite, specific type of pattern of behavior. And that's why the prosecution wants them admitted. What such acts, other acts evidence, is not admissible for is to argue that a defendant has a propensity towards some bad conduct. So if someone's charged with assault, for example, or battery, they're to be judged on the facts of this particular case. The fact that they might have engaged in assault or battery in previous instances in their life, and to argue that, hey, they've gotten into fights before, that means they got into this fight unlawfully this time, they have a propensity for violence. That's not normally admissible as evidence. Propensity evidence is specifically prohibited by the rules of evidence. So the other acts evidence has to be proposed for some other purpose. Now, it could go to motive or intent. As I said, there's a variety of factors that may make it admissible. But mostly for those to be the basis for getting these other acts evidence admitted, it has to be tied pretty closely to the actual facts of the underlying case, involve the same people or the same property or the same tools or the same weapons or the same beliefs or circumstances, something tied very closely to the facts of the case. And that was mostly missing here. So the first other acts evidence that the prosecution argued for in this hearing involved a purported assault. That's how the prosecution characterized it. An assault by Kyle Rittenhouse on a female, a woman, some months before the shooting in Kenosha. And the circumstances of that use of force, that was a June 1st event of that same year, 2020. The surrounding circumstances were that Kyle's sister and another girl got into a physical confrontation. They were basically in a teenage fistfight, and Kyle intervened in that fistfight on behalf of his sister. So the prosecution would like to get this admitted, they say, because it shows that Kyle tends to insert himself into fights that are none of his business, as the prosecution characterizes this. The prosecution says, hey, this was really a case of mutual combat. Two teenagers wanted to get into a fight with each other, and Kyle decided to unnecessarily insert himself into that fight. Now, if that already doesn't sound very credible to you, because, I mean, an alternative reading of this is that Kyle came to the defense of his sister, and what good brother wouldn't do that? Well, I'm right there with you. But in any case, the real difficulty is that even if what Kyle did was wrong in coming to the defense of his sister, which I think is an uphill fight already, the circumstances of this fist fight with the sister and Kyle intervening and striking the other girl who was fighting with his sister, purportedly, is so far removed from the facts of the Kenosha case that it doesn't seem to really have any relevance to it at all. Remember, the Kenosha case involved deadly force, chaos, riots, Kyle Rittenhouse purportedly carrying around a fire extinguisher to put out fires, being chased by each of the men and attacked by each of the men he ends up shooting. A completely different set of circumstances than a teenage fistfight on a pier someplace months prior to the Kenosha events. And the judge took that view as well. Of course, that was all the defense argument. It's simply too far removed in circumstances, in time, to be of any use to the jury in this trial in arriving at a conclusion on whether or not Kyle's conduct that night in Kenosha, his firing of those shots, his shooting and killing of two men and shooting and injuring of another, whether or not that was lawful self-defense. The teenage sister fistfight scenario really sheds no light on the Kenosha shooting event at all. And that was the decision of Judge Schroeder in this case. So he's not going to admit into evidence I believe it was cell phone video of that Kyle's sister teenage fistfight event some months earlier. So simply not admissible into evidence. So the sister fistfight is out. Of course, arguably, not only is it not relevant, but it might be prejudicial in the sense that it might show Kyle striking a girl. Our society in America has a generalized rule against men striking women. So it could have that prejudicial impact as well. Frankly, I don't think we even get there. I think it's so lacking in relevance that it's simply inadmissible on its face. The other acts evidence that the prosecution wanted to introduce before the jury was video, or I should say photographs of Kyle at a local Kenosha bar. It was called Puggies or something like that. Doesn't really matter what the name is. He was there. Of course, Kyle, we all know, is underage, 17 at the time. But apparently under Wisconsin law, you're allowed to be in a bar with your parent. He was there with his mother. And while he was there, he came to the attention of another group of people who were there, who asked to take photographs with him, who in the photographs made the OK sign. We all know that's this, right? I think they had Kyle make the OK sign. And it would turn out later that this other group of people were members of the Proud Boys organization. Now, I frankly don't know much about the Proud Boys. It doesn't matter. For our purposes, the prosecution presents the Proud Boys as being a kind of race hate organization, a kind of white supremacist, use violence against others on the basis of their skin color kind of organization. So something that would be generally considered vile in American society. Let's not get into whether or not that's an accurate characterization. That's the characterization the prosecution was putting on this case. And the prosecution is saying that because Kyle was in photographs with these people and Kyle was smiling and making the okay sign, which of course the prosecution says is a racist hand gesture, that this shows that the Proud Boys, their policy is to use violence at scenes of social unrest in unlawful ways. And that means that Kyle, that night in Kenosha, which was months before this bar event, by the way, that night in Kenosha, Kyle was also using force in unlawful ways. The Proud Boys do it. He took photos with them months later at a bar. That must mean that Kyle was also doing that, using force in unlawful ways in Kenosha. If that seems a stretch on its face, you'd be right to think that. More importantly, there's literally zero evidence that Kyle knew who these people were, that they were Proud Boys, that the Proud Boys is a thing that Kyle is even aware of. In fact, the defense took the preemptive step of sending Kyle's personal cell phone off to a forensics examiner to be effectively broken down and searched for any indication that Kyle had either communicated with or shown any interest in, even a Google search of anything like the Proud Boys or the KKK or white supremacy or whatever, any group that might be considered hate-based or racially motivated. And there was nothing on the phone. And if you're thinking, well, his own lawyers did that research, so surely it must be, a lie on Rittenhouse's behavior. Keep in mind, the prosecution's going to get the same cell phone, get to examine the same kind of content. So I think it's fair to take it at face value that there's literally zero evidence, that Kyle has any kind of white supremacist leanings of any kind, or any association with the Proud Boys in particular, or any other similar group. So that stretches the relevance even further of this bar, the photos taken at this bar meeting. Of course, there's also no evidence that Kyle went there to meet these people. He's got no relationship with them. In fact, Proud Boys were interviewed by the FBI right around the night, the immediately after these events took place, asking them what they saw, taking usual witness statements. And they were asked, each of those witnesses at the scene, hey, do you happen to know a guy called Kyle Rittenhouse? And none of them did. So zero connection in real life between any of these people. And in any case, the prosecution, and often throughout this hearing, the prosecution's arguments for evidence came across to my ear as rather incoherent, because the prosecution seems to be arguing in one breath that the Proud Boys are a racist organization, uses violence against others based on their skin color, much like the KKK, a white supremacist type of organization. And therefore, that kind of bad intent, racial malice should transfer over to Kyle. Well, we can already see that's a stretch because there's no actual connection between these cases. But even if Kyle was a member of the Proud Boys, which there's no evidence of at all, in fact, all the evidence is contrary, the people that Kyle Rittenhouse shot were, in fact, all white. 3 men, all white. So even if Kyle Rittenhouse possessed racial animus, that couldn't have been the driving force, the motivation behind his use of force against those particular 3 men, because they were all white, just like him. There is no racial dynamic here, folks. Rittenhouse is white. The 3 quote-unquote victims of his apparent defensive use of force, all white, no racism. So why does the prosecution keep trying to inject racism into this case? Well, it suggests to me, for one thing, that they don't feel they have a very strong case. So they're desperate to bring in these kind of ancillary, really non-issues, but try to make them appear to be issues because, of course, of how despised racism is in America, and appropriately so. If they can paint Kyle Rittenhouse with that brush, maybe they can get him convicted of murder for being a racist. If they can convince the jury that he possesses racial animus because he associates with this group and so forth. But the problem is, for the prosecution, there's no there. There's no evidence that he knew these people, that he's ever expressed any interest in the Proud Boys, that he shares any of their worldview at all. And much less, even if he did, there's no indication that would be relevant to the use of force in this particular case because there's no racial dynamic there. So that evidence, also the photographs of Kyle at the bar where he's in the company surrounded by those purported Proud Boys making the OK sign hand gesture, inadmissible as evidence in this case. The jury will not see them, at least won't see them in the courtroom. Who knows what the jury's seen already from the internet, of course. But they'll be asked to set that aside in the interest of being impartial and unbiased jurors. Hopefully they can do that. So those photographs at Puggy's bar in the company of the Proud Boys will be inadmissible as evidence in court. By the way, I thought a funny part of this hearing was this whole notion that the OK sign, which has been around my entire lifetime, I believe dates back at least to World War II, suddenly we discover that within the last year or so that this is supposed to be, I guess it was from the Supreme Court Justice hearings, confirmation hearings. God, I can't believe I'm blanking on his name. How embarrassing for a lawyer to do that. But it was at those hearings the first time I ever heard that an OK sign was a racial hand gesture. And the judge here noted that, first of all, the judge had never even heard of the Proud Boys before this case. And certainly the Proud Boys is new in my knowledge of the world. I haven't known them for any period of time. But the judge said, hey, this hand gesture, and the judge actually makes the hand gesture on the bench. So obviously he doesn't think it's a racial gesture or he wouldn't be doing it, right? Just like he wouldn't use the N-word on the bench. He makes the hand gesture and he says, hey, the first time I ever saw this, I was like a kid and I saw it on a can of Chef Boyardee canned spaghetti. So this whole notion that this hand gesture has any racial implication, even generally, much less to this case specifically, obviously the judge found completely ridiculous. The next evidence that not so much evidence to be admissible trial, so not other acts evidence anymore, but another piece of evidence the prosecution was trying to obtain was the list of donors to the Free Kyle donation organization, as well as there was another one mentioned, the one that's run by Lynn Wood. What was that one called? Something Free. It doesn't really matter, but both of these organizations have purportedly raised funds for Kyle Rittenhouse, and the prosecution wants the names of everybody who's donated money to these two fundraising efforts. Why would they want their names? Well, on the surface, the prosecution is saying, well, we want to make sure that anyone who donated wouldn't make it onto the jury because they made a donation. Presumably they're biased on this case, and we wouldn't want them to play roles as jurors. Well, okay, except traditionally what you would do is you would simply ask a prospective juror if they had donated in support of Kyle Rittenhouse's legal defense, and they would tell you. And we're supposed to presume that the jurors who are under oath are telling the truth. So, I mean, if they lie, they're subject to perjury charges. So normally that's how that's addressed. You simply ask the juror. You don't normally go to wherever the fundraising is happening and get a list of all their donors. In any case, the prosecution has not actually gone to these groups and asked for their donor list, which would seem the most direct way to do it. The prosecution is demanding that the defense team provide the donor list. Well, in the case of Lynn Wood's group, the defense team literally has nothing to do with that group. They may have had a relationship early on in this trial process, but that ended in last December or last January, almost a year ago now. They don't have access to Lynn Wood's donor list. Now, arguably, the other list, the Free Kyle donor list, that fundraising effort is run by Kyle Rittenhouse's mother. So the prosecution is saying, well, it's his mother who has the list. So he can ask his mother for the list. And in theory, he could. But the question Judge Schroeder raised was, but you're asking me to order him to compel his mother, a third party, to reveal information that's proprietary to her. just because she's his mother doesn't mean he has the power to compel her to do that. And I don't believe I have the power to compel him, the defendant, to compel his mother to produce the list. So the judge is not going to compel the defense to come up with that donor list. What's the real reason the prosecution wants a donor list? Well, the cynic in me would suggest that inevitably the donor list would be leaked. We've already seen, for example, a police officer who donated in the Ahmaud Arbery case was fired from his job. So this would have a chilling effect on anyone who wanted to support Rittenhouse's legal defense financially. They would now have to fear that their name would be made public. Maybe their employer wouldn't appreciate the donation. They'd lose their job. Maybe their neighbors would get mad at them. Who knows? It's all obviously in an effort to chill people from expressing their support of Kyle Rittenhouse in a way that's financial in nature through these fundraising efforts. So the judge said, well, I'm not going to compel the defense to try to compel the mother to try to produce this list. And certainly the Lynn Wood group is completely independent, so I'm not going to try to compel the defense to do that. By the way, if the defense already had the donor list, if it was in their possession, they might be compelled to produce it. But one of the issues here is they're saying, well, we don't have the list. We don't have a list of who donated. We'd have to compel it from these independent third parties, and the judge is saying he's not going to make them do that. Now, the prosecution did ask, hey, judge, if we ask for a subpoena, would you sign a subpoena compelling these third parties to produce their donor list? And the judge he just told them, well, listen, I'm not going to tell you ahead of time if I'll sign such a subpoena. So I'm not going to give you an advisory opinion here from the bench. And his overall demeanor suggests he's not interested. By the way, the prosecution can send out their own subpoenas. They can sign their own subpoenas. They don't need a judge to do that. But then, of course, whoever they send a subpoena to, these fundraising groups would argue it out in court. It would be a whole other circus. And I expect they'd be unlikely to win on the merits because now their subpoena is really independent of the criminal case. They're going after an unrelated, uninvolved third party, a party not involved in the criminal charges themselves, but merely helping out with the legal defenses afterward. So the prosecution lost on that as well. It does not appear, certainly the judge did not assist them in getting the donor list, said he's not going to compel the defense to do that. So that is all done for the prosecution. So far, not a great day, right? The sister fight, not admissible as evidence. The meeting with the interaction with the Proud Boys at Puggy's Bar, not admissible as evidence. The donor list is not going to be provided. And then there was another other acts piece of evidence the prosecution wanted. And this was a very recently discovered video of involving a robbery or a shoplifting. Who knows what actually happened, but stuff was being stolen from a CVS pharmacy. Kyle Rittenhouse was a passenger in a car parked more or less across the street, observing the robbery / shoplifting taking place. The thief was seen by Kyle Rittenhouse and whoever was with him, fleeing from the store with merchandise. And Kyle said something to the effect of, bro, I wish I had my AR. I'd send rounds at that person, or words to that effect. That's a rough paraphrase of what he said on this recording. So we don't see Kyle in the video. So, I mean, you might wonder, how do we even know if it was him? But effectively, the defense concedes that that was Kyle Rittenhouse's voice. He made that statement. And again, the prosecution is trying to get this other acts evidence, this CVS recording, admitted into evidence to indicate state of mind, Kyle's state of mind, his willingness to insert himself in conflicts that have nothing to do with him. And further, in this instance, his willingness to use deadly force in circumstances where it would not be justified. So the prosecution characterizes this as a shoplifting incident. That's a pure offense to property crime. You cannot use deadly force in defense of property in either Illinois or Wisconsin. I forget exactly where this event took place, but wherever it took place, deadly force would not have been permitted to be used in defense of property. The prosecution is saying, look, he was willing to use deadly force to stop a shoplifting, which was clearly unlawful. That shows that he's willing to use deadly force in unlawful circumstances, which is what we're arguing he did that night in Kenosha. Again, the facts are completely dissimilar from the CVS event to the Kenosha night event. First of all, at the CVS event, Kyle did not use force. He did not use any force. He did not threaten anybody with any force. He did not get out of the car. He did not honk the horn. He did not lower the window and yell out. He did not intervene in the criminal activity in any way. The only act he committed was he actually called 911 to report what appeared to him to be a crime. And of course, there's a record of that 911 call. By the way, the prosecution tried to characterize that 911 call as Kyle Rittenhouse taking the law into his own hands, just like he did that night in Kenosha. So apparently, according to the prosecutor, if you see what appears to be criminal activity and you call 911, you're taking the law into your own hands. Folks, when I see prosecutors make that kind of wacky argument in support of their case, in the absence of a strong argument in support of their case, it suggests to me they only have the wacky argument. And that's not a good place to be. And I think that's actually really the case here. Let's see what else we have here. I will say one thing. When the defense in this case was speaking to the judge, providing their counter arguments to what the prosecution was seeking to get admitted, they often resorted to using a lot of pronouns, a lot of he. He did this, he did that, then he did this, and he did the other thing, to describe events that involve multiple people, like Kyle Rittenhouse's interaction with Rosenbaum, being observed by journalist Richard McGinnis. And folks, I advise you not to do that when you're narrating some event to people who were not there, because all the pronouns get extremely confusing very quickly. Use proper names so people do not get confused. It's not how you normally talk. We normally use pronouns all the time, but if you're trying to communicate important information accurately involving multiple people, please use their proper names to avoid that kind of confusion. Let's see what else. The prosecution also made a big deal out of the fact that Kyle Rittenhouse had an AR-15. This is much along the lines of what happened in the George Zimmerman trial, where the prosecutor there, John Guy, made a big deal out of the fact that George Zimmerman not only had a Kel-Tec 9mm semi-automatic pistol that loads from the bottom, he had it with a round in the chamber in the ready-to-fire condition, said in a tone dripping malice to suggest, of course, that the jury in that Zimmerman trial should intake that as negative information about Zimmerman. Of course, there's nothing negative about any of that. It doesn't make any. There's nothing about having a Kel-Tec 9mm semi-automatic that loads from the bottom with a round in the chamber that makes using that gun not lawful in self-defense. Whether or not it was lawfully used in self-defense is completely independent of all those characteristics. But again, it's the kind of weak argument a prosecution makes when they don't have a strong argument to make. In this case, the prosecution made a lot out of the fact that the rifle, the weapon that Kyle used in claimed self-defense, was an AR-15 Smith & Wesson M&P model rifle. I don't know if any of that's true, but that's what the prosecution was saying in this hearing. An assault weapon, a weapon, because it was open carry and clearly visible, that reflects intent on Rittenhouse's part to scare people, frighten people, and of course, a way that's supposed to be negative, according to the prosecution. Certainly, someone open carrying an AR might be doing it partly to make sure other people are aware that they're prepared to defend themselves. It's not a practice I would routinely recommend, frankly. But there's a lot that Rittenhouse did here that I wouldn't recommend. That doesn't make it a crime. But I would expect to hear a lot at trial about the fact that this was a AR-15 style, quote unquote, assault rifle being carried by Rittenhouse, in the hope that some of the jurors are going to perceive this in a negative light, that they don't own their own AR rifles. I mean, it is the most popular rifle in America, but for some, if you have an anti-gun juror, they may perceive the rifle of this type as being no better than a rattlesnake being carried around in public. Who knows? It's a kind of rhetorical argument prosecutors are wont to make, again, especially when their underlying case is weak. But I expect we'll hear a lot about that at trial. I will point out, of course, that, and by the way, the prosecutor did say, hey, there were other people in Kenosha that night who were walking around with guns, but they were carrying like semi-automatic pistols, like Glocks that were concealed. So nobody would know they had a gun. So they weren't terrifying people with all this open carry nonsense. And of course, really, first of all, the prosecutor has to concede that because the quote unquote victim here who was shot and injured was armed with a Glock pistol, was about to shoot Rittenhouse with the pistol. We can clearly see that in the video. So the prosecutor has to acknowledge that there were others there also armed. So he chose to use this opportunity to do it. But in fact, of course, there's a very sound and reasonable legal basis for why Rittenhouse didn't choose that option of carrying a Glock semi-automatic pistol concealed. It would have been a crime. He's 17 years old. Under the law of Wisconsin, he's not allowed to be carrying around a gun. Maybe not allowed to be in possession of a gun. Again, I don't do gun law. I do use of force law. But certainly he wouldn't be legally permitted to be carrying a gun concealed around in public at the age of 17 under Wisconsin gun law. So that was not a lawful option for him. Rather than it being a bad thing for Kyle not to have done that, that was a good thing. That was in compliance with the law. Ironically, it is permissible for a 17-year-old in Wisconsin to open carry an AR rifle. So Kyle was arming himself in the manner that was lawful, contrary to the prosecution's suggestion that perhaps he should instead have armed himself in a manner that would have been unlawful. This is another example of ways in which the prosecution's arguments in this hearing came across to me as being rather incoherent. There was also a funny part here where it came up in conversation with the judge. The prosecution tried to, there was one point, if you've seen the videos, and I'm sure you all have, that Joseph Rosenbaum, the first man shot here in the car lot, throws a plastic bag in the direction of Rittenhouse, misses him by about 10 feet. And the prosecution is trying to explicitly suggest here that, hey, Your Honor, this was only a plastic bag, so we know this could never have been a basis for Kyle being in reasonable fear of serious bodily injury that would justify the use of deadly defensive force. And the judge actually stops the prosecution and says, oh, well, wait a minute. If I throw a plastic bag at you, just a plastic bag, from here, I guarantee it wouldn't hit you. And in fact, that would be true if I was standing 2 feet away from you and I threw a plastic bag in your direction, it would never reach you. We all know this. Plastic shopping bags don't have the momentum to travel any distance. What was the characteristics of this bag? Was it thrown a distance? And the prosecution had to concede that, yes, obviously there was an object inside the bag, or it wouldn't have carried as far as it did towards Rittenhouse. So again, it kind of a silly, superficial, a forced error, really, on the part of the prosecution that the judge called him on right there to his face. So another reason I say Judge Schroeder seems to be a very sound judge to me for the purposes of this trial. Then there was, so that went against all of that so far. Everything I've described so far went against the prosecution. They wanted the sister fight video, not admissible. They wanted the bar with the Proud Boys photographs, not admissible. They wanted the CVS video, not admissible. They wanted the donor list to the fundraising organizations. Judge is not going to compel the defense to produce those records. Doesn't believe he has the authority. There was a shortcoming on the part of the defense, too. There was a piece of evidence they wanted to bring in, and this centers around the fact that Joseph Rosenbaum, the first man shot and killed by Kyle Rittenhouse, was a convicted pedophile. And they'd like to get that evidence into the record. Now, the defense itself pretty much concedes that the prospect of them getting in the pedophile, by the way, multiple pedophile convictions on Rosenbaum, the prospect of getting the fact that Rosenbaum was a repeatedly convicted pedophile into evidence in this case is basically zero because of the low relevance. But they were asking the judge to at least allow into evidence the fact that Rosenbaum was a convicted felon. Well, why would that be admissible? Really, on its face, it's not admissible, unless that information were known to Kyle Rittenhouse, which it was not. Kyle Rittenhouse didn't know who Rosenbaum was, didn't know anything about these prior convictions. So what was the defense argument to try to get this evidence into the record? And the argument basically is that the defense believes that the reason Rosenbaum attacked Rittenhouse, that's of course the defense position, that Rosenbaum attacked Rittenhouse, that's why Rittenhouse shot him, was to steal Rittenhouse's rifle, was to steal the gun. Stealing the gun by itself would be a felony under Wisconsin law, so that would be a forcible felony. Also, of course, Rosenbaum, as a convicted felon, a prohibited person, would be committing his own crimes by now being in possession of a firearm. That's another felony of which Rosenbaum would have become guilty if he'd obtained possession of the gun. Also, of course, as a prohibited person, Rosenbaum's not free to simply go purchase an AR like most of us, if we live in free parts of the United States, are able to do. So the defense kind of narrative here, story here, is that Rosenbaum, a prohibited person, can't just go buy a gun. He saw an opportunity when he got Rittenhouse isolated to steal Rittenhouse's gun and therefore obtain a firearm and be armed in the midst of all this chaos. And that could be an effective narrative, except for the fact that there isn't an underlying evidentiary foundation for it. The notion that Rosenbaum had the intent to steal Kyle's rifle is really just speculation. There's no record that indicates Rosenbaum had previously stolen rifles, was seeking to steal a rifle, had threatened to steal the rifle. Now, Kyle doesn't need that for his self-defense claim. The mere fact that someone's attacking him while he's armed can be more than enough to reasonably perceive a deadly force threat. Obviously, the person attacking an armed man isn't in fear of the gun, presumably because they believe they can overcome the weapon and or take the weapon for themselves. So it doesn't... If Kyle would reasonably perceive that, that's enough to support his claim of self-defense. It doesn't have to be true or accurate. But if they want to admit this evidence of the prior convictions of Rosenbaum, then this narrative would actually have to have some evidentiary foundation beyond what it has here. Now, what the defense argues is, well, it's true Kyle didn't know of Rosenbaum's pedophile convictions, but Rosenbaum was, previous to the shots being fired, getting in the face of Kyle and other people, making statements in the presence of Kyle that, hey, I'm not afraid of going to jail. I just got out of jail yesterday or last night or whatever the case might be. So it turns out, of course, he had just been released, not from jail, actually, but from a mental institution, basically. So he was obfuscating there. Rosenbaum was obfuscating and making this boasting claim. But it doesn't really matter if the claim's true or not. What matters is, did Rittenhouse overhear it, and would he believe it? And if he believed that Rosenbaum had just been released from prison, would that play a reasonable role in his perception of threat from Rosenbaum? So the judge did not make a definitive ruling on whether he's going to allow Rosenbaum's prior convictions into evidence, but for those boasting claims by Rosenbaum that he'd just been released from jail and wasn't afraid of going back. But for those boasting claims, there's no way that prior conviction evidence would get in. But in the context of those boasting claims and the influence they could have had on Rittenhouse's state of mind in reasonably perceiving a threat, the judge may allow some variation of that evidence, the previous convictions of Rosenbaum, into evidence in front of the jury. I think it's likely a decision he'll make in the moment during the trial. He'll make it on the fly, depending on how the narratives have developed up to that point in the trial, and then make a snap judgment based, of course, on his many years of experience and legal doctrine and so forth, on whether or not he's going to allow that into evidence. Almost certainly not the fact that they were pedophile convictions, because that would be highly prejudicial, but perhaps the fact that Rosenbaum had prior felony convictions, making him a prohibited person. All right, folks. Well, I see I'm almost at the top of the hour. And believe it or not, I'm on page 36 out of 67 of the transcript I have of this hearing. So I'm only about halfway through. So there's much more to cover. In fact, you know what I'll do? I think I'll actually stop here. And it'll probably take me another hour to go through the rest of it. There are a lot of additional issues to cover in this hearing, including, by the way, the defense desire to bring in an expert witness on use of force. It sounds to me they only provided the last name of this expert, a Dr. Black. I suspect they're talking about Dr. John Black out of Portland, Oregon. I'm not sure about that, though. They weren't very clear about it. I think that's who they're talking about. But a very interesting issue here was the judge appeared to be very resistant to allowing a use of force expert into the case at all, either for the defense or for the prosecution, because, of course, if the defense brings one in, then the prosecution will bring one in as well. So they're going to have a separate hearing just on that issue. Will the defense be permitted to bring in a use of force expert witness? And the judge appears to be rather strongly disinclined to allow a use of force expert witness to testify in the case. And if you don't understand why that might be, and frankly, it's probably the right call, given the facts of this case, well, then I would encourage you to join us for part two, an unplanned part two to our breakdown of the Kyle Rittenhouse pretrial evidentiary hearing that took place last Friday. All right, folks, remember, before I depart, I'll remind all of you that you can get much, much more detailed coverage of all this by becoming a Law of Self-Defense member, including the transcript I mentioned, videos of our analysis of this case as it moves forward. You can try out Law of Self-Defense membership by pointing your browser to lawofselfdefense.com/trial. Try it out for 99 cents. You get unlimited access, folks, just like you were a long-standing member of Law of Self-Defense. It's not a limited trial. It's a full-blown trial. All our content, hundreds of hours of video, podcasts, blog post analysis in plain English of various use of force events and trials. Try it for 99 cents for 2 weeks. If you don't like it, cancel your membership. We'll give you your money back, give you double your money back. And if you stay a member, it's only about 25 cents a day, folks. It's less than $10 a month to get this kind of insight and expertise on a regular basis, usually almost daily basis. So I encourage you to try that at lawofselfdefense.com/trial. Until next time, see if I can do this correctly now. Until next time, I want to thank all of you for joining me again this week at our Law of Self-Defense News and Q&A show, the rather unusual Kyle Rittenhouse specific edition for this evidentiary hearing. And until next time, remember, if you carry a gun so that you're hard to kill, that's why I carry a gun, so I'm hard to kill, my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so that you're also hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.